This is an interview with Carmen Lawrence for the SEC Historical Society's Virtual Museum and Archive of the History of Financial Regulation. Today is November 11, 2021, and I'm Kenneth Thayer. Carmen, it's great to talk to you today.
Oh, it's great to be here. I'm very excited about our interview. I'm sure we'll have fun.
I think so. Well, let's go back to some of the fun things about your education and how you went. I guess you started out at Cornell.
That's correct. I was in the arts and sciences and graduated in '78, and then went on to University of Michigan Law School and graduated there in '81. In Cornell, I was a government major.
Okay. Did you know you wanted to go into law at some point?
I did. It's one of those things where your parents have an influence on you. And for whatever reason, I really loved math and science and thought that that's where I would be headed. But my dad convinced me that he saw me as a lawyer, so I didn't fight. I didn't push back.
Okay, so you went to Michigan for law school.
Yes, yes.
Did you take some securities courses?
I did indeed. I took securities regulation as an elective, and as odd as it may sound, I really loved it. I think what appealed to me was the statutory framework, but yet there was, sort of the case law that put the gloss, as well as interpretations from the staff and the like. So I really did enjoy it. But I think one of my professors had an influence on me. He had become a mentor, and that was Professor Ed Cooper. And he's of Wright, Miller, and Cooper fame, the treatise on federal procedure. And I had become his research assistant for my second and third year. I had done fairly well in his course. And so we would talk about opportunities as they presented themselves, and he was very influential in my decision to go to the SEC.
Why precisely?
Why he was influential or why I went to the SEC?
Why was he telling you the SEC was the place to go?
Well, because, I had a number of opportunities with big law, and it was his view that, at that time, government agencies were accepting, candidates out of law school. And he thought that the SEC was a real premier agency, and that I would, really have hands-on experience that would, sort of open doors for me after, and I would, sort of leave there after, he thought, 2 or 3 years with real practical experience, and not just, as it's looked at in terms of associates at law firms spend their first few years, doing research memos and things of that nature. So it was kind of a bias towards government experience versus, early associate law firm experience.
So you can sort of get litigating a little earlier, I guess.
Yes, yes. I think so. I think so. But I think the main influence that led me to the SEC is that my roommate actually first year of law school had, after our first year, had done an internship in the Atlanta regional office, and really just came back very excited, loved the work that she had done in the enforcement division. And regaled me with stories, not divulging any confidential information, but what she could. And when interview season had started, one day I was in the area, and there was I had a gap between interviews. And there was, as I passed by, one of the interview rooms, the SEC was there. interviewing on campus, which is, very unusual these days. And they had a gap in their schedule. So I knocked on the door and said, I'd love to talk to you. And they said, well, we'd love to talk to you. And so I sat there and interviewed with them for the 30 minutes, and just really was very impressed, and with the passion and enthusiasm, commitment, that came across from the interviewers there, that I certainly didn't, get that feeling from the interviewers that, other interviewers that I was interviewing with. And got a call back to the home office, and you interviewed with all the divisions there, and the regional offices were represented there as well. And I got an offer from Division of Enforcement, Office of General Counsel, but not the New York office, as funny as that is. So ended up starting at the division.
Yeah, so you started out with enforcement, is that right?
Yes.
Okay. So you moved to DC then?
That's exactly right. Out of law school, I moved to DC, even though I was from New York. So I spent my first 2 years in the division there.
Okay, tell me about those first 2 years. That was starting around 81, right?
That's correct. That's right.
Yeah. What kind of work did you do?
I was regular, staff attorney, new to the division. And in my class, I think there were maybe 3 others. There were 4 of us all together that were new to the division. Was started in a branch and started getting cases. I think very very soon after starting, I was assigned to the Paul, was now known as the Paul Thayer case.
Okay.
Which was, because of its significance and because of its breadth, pretty much took up all of my time.
That's would have been a good case to get started out on.
Yes. Of course, it doesn't, it did come in with sensitivity, because it was, as I recall, there was an anonymous letter that, targeted Paul Thayer and said that he was divulging material non-public information to his friends. And so, right off, it clearly had certain sensitivities, since he was Deputy Secretary of Defense. And so a lot of interest from, all of the senior enforcement folks. But it was a lot of hard, painstaking work, because, there were no data analytics, at the time. We did it the old-fashioned way. I to this day, I'm still surprised that we were able to bring any insider trading cases the way you're, looking at the blue sheets and making the index cards and putting the zip codes together. Is really quite ridiculous when you think about how we had to, build these cases at the time.
And Thayer was involved in lots and lots of trades.
Yes, and it's interesting. What we did was, he was on obviously a number of boards and had relationships with others that were on boards, and so we took, like, he was on LTV, and he was chair of LTV, and then he was on the board of Anheuser-Busch. So we started looking at, and Anheuser-Busch was quite, acquisitive, so to speak. And so we started looking at, the acquisitions that Anheuser-Busch was making in some of the corporate events of LTV. And it happened to compare nicely in terms of, the timely trading. And it wasn't, Paul Thayer who did the trading, but we happened to, he had a broker who really he had done, he had a lot of his trades through that broker, and the broker was putting trades through for his friends. And because of that, the volume of that trading, which was also timely, we were able to back into that pretty well.
And this is a period when insider trading is starting to become kind of what the SEC is known for, really.
Right.
Part of it.
No, that's exactly right. Very true. So I seem
Uh,
to have a bunch of insider trading cases when I was in the division, and mostly, like I said, Paul Thayer was the case that was um, most time consuming.
okay. Now, you would have, while that case is moving through, you would have gone to New York. Tell me how you
Uh,
got there.
yes, at the tail end, that's correct. I was married. I got married, and actually, after year one in the Division of Enforcement, so I was commuting. My husband and I were commuting. He was a an attorney at Walgotchel and doing bankruptcy and restructuring work. And New York was the spot for that. And so um, after I did the vast majority of the Paul Thayer matter, I transferred to New York to complete that. And that was a funny story because the reason I didn't get the offer from New York, I think, is because Ed Nordlinger, who is fairly well known and very beloved, he unfortunately just passed away a month or so ago. But he had interviewed me when I was on site for the callback interviews, and Ed had a very unique interview style. He thought that if you work for the government, you should know something about the government, and so he asked a lot of government questions like what's a pocket veto and things like that. It's just a little bit of absurd. And being a government major, I knew all those answers. So after about 10 or 15 minutes, and I was pretty, a little bit cocky at the time, I was like, do you think we could talk about the SEC now in the New York office? And he was sort of like, well, no, I'm not done yet. And so it deteriorated from there. So the thought of having to interview with Ed, to transfer to the New York office, I just knew that he would remember and would reject my transfer. But of course, he did not remember me at all. We had a great interview, and of course, I had already, I had 2 years under my belt and had done some good work for the division. So was able to transfer to New York, and a few years later, I did talk to him about it. It was our private little joke. We would laugh about it all the time.
Hmm. So was Ira Lee Sorkin the regional administrator at that point?
Yes, yes, he certainly was. And Ike was he was fantastic. He had a very interesting style. He was very sort of deferential to the staff. He sort of had the perspective that the staff was closest to the facts, so therefore he gave deference to the staff's decision making. He would kick the tires at a very high level, but pretty much would be supportive of the staff's decisions around the investigations. But he was a great motivator. He was just inspirational. He knew everyone. He knew what matters they were working on. He would pop up during a testimony session and join. Of course, the witness and the lawyer would have a heart attack. The regional director sitting in on their testimony, they would just knew that they were going under the jail. And then we would take a break, and he'd give you a pep talk afterwards, and some pointers and things like that. He was just full of energy and positiveness while he was there.
You had two perspectives at this point. You'd seen what it was like at headquarters and enforcement. Compare and contrast that to being in the regional office.
So, it was a very interesting time about those dynamics, because and I must say I had a little bit of difficulty transitioning, because I mean this sounds absurd now, but it was viewed that I was a plant, I was a spy. for the division at headquarters. And so people were sort of somewhat, suspicious. It seems odd to articulate that, to express that thought now, but it was very true. There was a sense that the regional offices were not as the quality of the work in the regional offices was not as up to par as the work that was being done by the Division of Enforcement and the headquarters, and that the regional offices had to sort of report to and through the division. So the relationship, I think, between the home office and the regions at the time was not great. It wasn't bad, but it wasn't great.
That's interesting. I would think at the New York regional office, being the big show as far as the regions are concerned, there wouldn't be that much of an us against them kind of a thing, but I guess there was.
Yeah, I think it there really was. I mean, I didn't, there was a very, quick transition, sort of away from that. I think when Gary Lynch became division director, and then especially when Bill McLucas became division director, and then I think that there was much less, and then it was of that dynamic. I also just think that the offices and the division worked more closely during that time, and so as opposed to sort of somewhat separate units, and that helped the dynamics and the relationship going forward.
Right. Well, let's keep moving along. We could the dynamics of the regions versus headquarters is interesting. I mean, I think some of it might have been that there was a long period where the regions are slowly losing autonomy.
That's correct. And just I should also mention Jim Clarkson, who was sort of the regional liaison, who and when I got to more senior levels and became aware of Jim's involvement, so I don't know exactly when he took that position, but I know that he was very, very important to sort of building that positive relationship between the regional offices and the home office. He kept his finger on the pulse of everything, and he's just a wonderful guy, very savvy about the commission, just about people and their nature. I mean, he was really an incredible asset to the commission and to the regional offices, and gets a lot of credit as well for the buildup of the relationship.
Okay. Well, before we move into cases, let's cover a couple more organizational things, and moving into the late 80s. Let's see, Sorkin left, and you had a very brief period of sort of, it looks from the outside, a pretty tumultuous period.
Yes. That's true. We had very short. I don't know how long Kathy was, regional director. Maybe, I don't know, 9 months. I didn't look that up. Again, I think I was at the time just a new assistant director in the office. And I think after Ike left, the expectation was that Ann Flannery, who had been head of general enforcement, because as I'm sure people know, at that time, the enforcement groups were divided up So that you had broker-dealer enforcement with the exam program, broker-dealer exam program, asset management enforcement with the asset management exam program. And then there was the general enforcement that sort of did, everything. And Anne Flannery was the associate director, and it was understood that she was the heir apparent. And so when that didn't happen, she left pretty quickly. And I'm not sure exactly how things derailed so quickly, but certainly it seemed that that Kathy was there were issues that she had with the general enforcement group. Not quite sure why it was targeted significantly at me. So there was a lot of staff abuse generally, and and our work went to a halt. She refused to sort of review work and to process, our recommendations so that they would go to the division for review and to the commission. And so,
is this a differ? Did her approach differ? Were her priorities different?
I think she was, for whatever reasons, a little bit less comfortable with the law that in terms of some of the cases that we were focused on at that time. Microcap fraud, it hadn't sort of surfaced quite to be the problem that it ultimately became, but it was starting in that direction. And and some of the legal theories she wasn't comfortable with. So I think there was a little bit of that. And then there were other things. Just she would well, let me just say that I think it was a combination of things. I think there were some personality issues. I think there was some a lack of familiarity with some of the legal areas that we were pursuing, and it was creating an extreme problem for us to do our work. And I shared that with Gary Lynch when it got to an extreme point, and he took it to OGC. And I think it was known that OGC then they did an investigation, and she departed shortly thereafter.
Okay, and Jim Clarkson, who you mentioned, kind of filled the void for a little bit.
Yes, he did. Yes, he did. Yeah, it was great having him. I mean, I'm sure it was quite a burden for him, because he was spending a number of days in the office and going back and forth. But some shuttle between DC and New York, you get there faster than commuting from New Jersey to New York sometimes.
Right.
So yes, but he was very selfless and gracious with his time, and did a great job.
And they brought Lawrence Eisen in, and
Yes.
he apparently worked out pretty well. Tell me about his leadership style as compared to Ike Sorkin's.
Yes, Larry. I learned so much from Larry. He actually, he promoted me from assistant director to associate director and head of enforcement. He, very, very different style. The weight of the responsibility for the impact that enforcement actions have on companies and individuals weighed on him. And not that it doesn't weigh on all of us, but it really weighed on him. And he sort of applied, if I could, sort of a criminal standard, if you will. It had to be beyond a reasonable doubt standard. in his mind. He had to be certain in his mind that, and more probable than not, sort of didn't do the trick, even though that was the legal standard. So there was much debate, lots of challenges, to the cases and to the facts. And he really made us, put us to our proof, which I believe me, I thought was the right thing. But he taught me that, just because, a case is legally sufficient, that just because you can bring that case, think about whether you should bring that case. Does it serve justice? And if so, what does that look like? And it was something that was very powerful and really, stayed with me the whole time. Trying to get it right, trying to get to the right place.
And does some of that have to do with the notion of figuring out which cases send the biggest signal? Tell the right people that we're looking at this kind of thing?
I think it was a combination of things. I absolutely agree that there was some of, whether, what is the deterrent impact. I mean, but I think it was more than that. I think he focused on, in particular, the reasonable likelihood of future violations. He would look at a matter and say, in simplistic terms, does this company have a bad culture? Is this a bad person? Or was this a misstep? Have they learned their lesson and we're not likely to see them again, because they will have, learned the lesson from this experience. So it was really more in terms of, should we be bringing that case? Is this someone that is, likely to be a recidivist? Do we need to get that injunction? So there was a lot of that as part of it, and of course the egregiousness of the action. Right. There were lots of victims, and the lot of intentionality in terms of the misconduct. Those are the things that also would factor into his assessment of, whether this, what's the culture of this company, or the character of this person.
Okay. Well, let's. So you talked about your promotion. You were basically running. You had your own enforcement group, right?
Yes, that's correct. Which ultimately, and I think can't remember if Larry did this or Dick. It might have been Dick. That collapsed all of the enforcement groups under me.
Okay.
And left, so the exam under Marty Kupperberg and Ed Nordlinger, and I think asset management, it was Doug Scheit previously, and then Rick Marshall was hired to lead that group. So I think it might have been Dick, that because Ed maybe became his deputy, Martin became the head of the exam program, and all of enforcement moved under me.
Okay. Well, let's talk through some of the cases and some of the ways that enforcement changed over this early period. One of the early ones is the Yuppie 5 case.
Yes.
Yeah, and I mean, it's obviously it took a lot of work to put this thing together. The thing that was notable was at the end when the judge kind of decided that he didn't like the settlement.
I don't remember that all that much. I don't remember it at all, actually.
Okay. Were you involved in that case?
I'm sorry?
Were you involved in that case?
Yes, definitely. That was the Paul Weiss, Michael
Right.
David, right? The
Right.
Paul Weiss associate, and he had it was a crew that several of whom were in the industry that they shared material non-public information. But I don't recall as I sit here the issue
Yeah.
with the resolution. Do you have any facts around that?
Well, it's just the judge refused to sign the consent decree.
Oh my goodness, I do remember. Oh my gosh, yes, yes, yes. Oh my gosh, I absolutely. How do you know this? I absolutely remember that now, and oh my gosh, and so I wrote quite a letter to the judge talking about how he should be given considerable deference to the SEC and its judgment and our determinations on this, and it was pretty strong. And he set a hearing and had the press. I remember I walked out, I was stunned. He said argument, not a hearing, and the press was there, and he basically just I had already, had his decision written and just really, I would say dressed me down would be maybe a strong, would be a little bit too strong, but he sort of put me in my place that, yeah, you sort of get deference, but that the judge is not a rubber stamp. They have a job to do. And, there's what he's the role that he's playing is an appropriate role and the like, and that he intends to follow through on that. So it was a point that put me in my place, shall we say. I don't know what got into me with that. I just, it's sometimes you sort of have in your head that, well, wait, this is outrageous. What is the judge doing? It's our determination, and you should just sign off on it.
Right.
So
And that's the way it had been mostly. Um,
exactly.
yeah.
Exactly. Now, go fast forward, a little bit later in time, and we saw that quite a bit with Judge Rakoff, and a number of significant settlements where he was really, you talk about kicking the tires and questioning, come in and explain yourself about some of these. But at that time, it was just absolutely, I never experienced that.
Mhm.
And totally slipped my mind about
Yeah.
that. Yeah, it's quite the moment.
So, I mean, there was this tension and from that period on, there's this tension. Richard Breeden, when he comes in, he wants, his famous quote about being naked and without wheels. Um,
Oh my goodness,
he
yes.
he he puts a priority on making the settlements pretty tough.
Yes. Absolutely. Well, look, he was I'm a big fan of the former chairman. I mean, he was very pro enforcement, and he was tough. He was tough to the internally as well as
Mm.
externally. He did not suffer fools, gladly, and you had to bring your A game or don't show up at all. And but he was pro enforcement, and there was an expectation that we were to use the tools in our toolbox and try to use them most effectively. And he didn't want to see some milk toast, settlements, especially after he had, he had marshaled through the Remedies Act, which had provided a number of additional remedies for the commission. So he was like, use these because there's a lot of misconduct going on out there, and we need to stamp it out. So
And
yes, we had, he expected more harsher sanctions, and some settlements we just didn't get, and we had more litigation as a result. But
okay. Well, let's talk about times when you did use the toolbox and some of the interesting cases. And we talked earlier about this is the decade of insider trading. So
Yes.
naturally, you've got some of those. The Motel 6 case, for example, which you've got a very large group of defendants.
Yeah, that huge case. I don't know how many at the end of the day, maybe 25, 30. And, it was one of those cases where you talk about, um, it was like a waterfall effect. There was a corporate executive of Motel 6, his communications executive, Hugh Thrasher, and he tipped one of his friends. And then his friend became the town crier and told, he told his friends and family, and his friends and family told their friends and family. So there was a huge number of levels of tippees. I'm not so sure that, today, that many levels, could survive, under the current state of the law. But, at the time, it was a number of levels of tippies, and it was a lot of litigation. And it was all, sort of successfully resolved, but it took a number of years, but a lot of money and a lot of people, and it took a lot of resources investigating that matter. Robert Blackburn, who was a senior counsel in the New York office, gets substantially the credit for persisting on that matter and running it to ground and litigating it to ground. It was a great case.
Okay. And then there's the Southampton insider trading case.
Yes, the group of socialites. This one got awful lot of attention because first of all, the key person at Down, who was, I think either at the time or, had just been a director of Bear Stearns. He was married to Charlotte Ford, or had previously been married to her. And, his circle was the who's who of business and society. And you had Martin Revson, who was the co-founder of Revlon, and you had Fred Sullivan, who was former chair of GITA. So there's just a lot of the seven, if you will, were people very high in the C-suite. And what we found was that they had exchanged material non-public information between and among each other. And the what really, I think, enabled us to unravel this scheme was that Ed Down traded through his broker, and the broker had maybe 100 accounts. I'm sure that's an exaggeration, but not much of Ed Down's family and friends. And he was very big in the art world. And so there were a number of artists that he was helping to support. And the broker, Milton Wanger, is at Oppenheimer, would trade for the benefit of those accounts at Ed Down's direction. And because there was so much volume there, we started to focus on Milton, and that enabled us to work backwards and get to the heart of the matter. But another, case where, there's no data analytics. We're back to, blue sheets and the index cards. And I think we maybe had some computers. So I don't even think we were able to use Excel, but at the time. But again, just painstaking analysis and backtracking of trades and some great investigative work and testimony.
Yeah. So at all points here, you're sort of tallying up trades and showing where they came from and where they went. I imagine you're also looking for that letter or that email that specifically states, we want to do this, we want to do that. Did you ever find things like that? Did that ever sort of materialize?
I think not so much. In this particular case, I think there was, perhaps some of that in the Motel 6, but I'm not sure that on the Southampton 7 that it you know that I think phone records, as I recall, played a pretty important part at the time, and actually, tracing calls that were being made to the broker and timing them along against, uh, you know, times when people were in board meetings or had learned particular information. I remember in particular that the phone records played an important part in our proof for the Southampton case, but I'm not recalling an email. Maybe you
Yeah.
can. Do you know?
No,
Was
no,
there?
no.
Did we charge something in our complaint that the email was a gotcha?
No, no, not at all. I'm just thinking in terms of, the difficulty of building a case where you have to
Right,
prove intent to defraud.
right,
Um, and you're really talking about just building up this huge amount of circumstantial evidence.
exactly right.
Yeah. Well, let's move away from insider trading and talk about a really big one, and
Yeah.
which is Towers Financial. Now, I think I read that at some point it was considered to be the biggest Ponzi scheme to date, or something like that.
Yeah, certainly at the time, I mean, it was really huge. That was a really quite an interesting case for a number of different reasons. I mean, first, when Tower Financial first came to our attention, it was really we saw that there were, we had questions around the financial statements and its business, but we observed pretty quickly that they were engaged in an unregistered distribution of securities, offering of securities, and so we made a strategic decision that rather than maybe investigate for investigations take a long time, a couple of years, we should just try to put a stop to it by bringing a section 5 case, um and maybe they would sort of get religion, and we sort of didn't know that there was obviously a Ponzi scheme or a financial fraud, but we had some questions, but we thought let's just put a stop to this and make them, if they're going to sell securities, go through the offering process.
Right.
And then I'm not sure how it came back around to our attention, but then we realized that they didn't get religion, and we opened up an investigation and figured out pretty quickly that it was a financial fraud. From an accounting perspective, of course, and that it was a Ponzi scheme, and that some of the monies that they had been raising were used to pay, investors that had pay out investors that had invested in Towers Financial, and it was complicated by the fact that Steve Hoffenberg, who kind of was the I don't know, president, CEO of Towers Financial, was making a bid for the New York Post, which is sort of a New York institution. The Post was having financial difficulties, and there was everything in the press about how Stephen Hoffenberg was going to come in and be the savior. So there was all this attention around Hoffenberg, and then of course Ike represents
Right.
Towers and Steve Hoffenberg, and how eloquent Ike can be in his arguments. So it was really interesting. We quickly landed on the fact that there's a lot wrong going on, and went into court on a expedited basis to seek a TRO, and basically got thrown out of court by Judge Knapp, who, you know, frankly accused us of grandstanding, thought that, we're just trying to, uh, it seemed a little illogical, but that we were just going after Hoffenberg because he was a person in the media right now, and trying to somehow disrupt his efforts to save the Post and make a name for ourselves. It was very, disparaging comments, threw us out, said we had to give notice to Towers Financial. Um, and so we obviously we did, while we were thinking about whether we needed to mandamus, or what our next step was going to be around the TRO, because we were very concerned. We didn't think we had time, which is why we went in on the TRO, and then either later that night or the next day, Judge Knapp signed off on the TRO, apologized, said he had read our papers and better understood, our case at the time. So
Interesting.
yeah.
And
Yeah, it was really something. It was really something. And I
yeah,
think we I'm trying to think, it was myself, my team, we went in, we didn't think we would have an issue on the TRO to argue it. And then I know that there were a couple of other motions before the judge, and Dick Walker was very involved, and did some of those arguments as well. So it was really a very interesting case. Very interesting.
were you in touch with the commission on a regular basis about this?
Very much so, and in particular, the Office of General Counsel. One of the unique aspects of the case is that we had as I said, the judge granted the TRO, but then we did, on the preliminary injunction, we resolved, did a settled PI. And one of the things that we did was that we required that, while we recognized that a part of Towers Financial was a real business, and they needed to keep that business ongoing for the best interests of the shareholders, we were very concerned about, the assets, and that they be appropriately dispersed. And so I became sort of like the CFO for Towers Financial, and had to sort of approve, every, bill, every expense that was paid, every expenditure and the like. And, there were issues that would come up, and would require consultation with general counsel's office, and things like that. So, and not to mention some of the issues that came up with the judge. Our experience with Judge Knapp was mixed. And so there would be times when we needed to consult with OGC in terms of the positions that we were taking, and the arguments we planned on making, and and get their thoughts on some of it.
Is this a matter of wanting to, sort of go after Hoffenberg deservedly, without sort of undermining the corporate enterprise that all these investors are invested in?
Exactly. That's exactly better said than I had. Yeah, that's exactly right. That was the goal, and to ensure that what could be salvaged, so that investors didn't lose all of their investment, but what could be salvaged was salvaged.
Yeah.
But sort of lobbing off, if you will, the bad parts.
How did it turn out?
How did it turn out, Kim?
Just generally speaking, I mean, I think they had to go into bankruptcy at some
They
point.
did go into bankruptcy. That's right. That's right. They did go into bankruptcy. I am not, I'm not remembering exactly sort of how things unfolded and got to that point.
Okay.
But you're absolutely right. They did. I
Okay.
remember that now.
You mentioned Dick Walker, and he was in as regional administrator at this point.
Yes, yes, he
Um,
was.
and he was there when the big reorganization came through.
Mm-hmm.
And I want to talk about that. I mean, you were early on, you were talking about this us against them thing, and maybe the sense that New York had perhaps lost power over the years. But now all of a sudden, you're the regional office, and you've got Boston, and you've got Philadelphia, you've got this huge empire. What was the effect on the New York office of this change?
Well, I mean, I think. Well, look, I think first of all, it obviously was increased workload that for all parts of the office for Dick, who now had supervisory responsibility for those offices, me for the enforcement program of those offices, and the exam aspects of those offices. The heads of the exam programs had now responsibility, so it broadened all of our scope of work. I think it also, we were very mindful of, to the extent that this had somewhat of a demoralizing impact on, our colleagues. We are all on the same team. And so, finding the balance of, doing our jobs and having responsibility for the oversight and needing to do that while preserving their independence to some extent, and the respect for them and the work that they were doing. So it was it was really in the beginning, had some bumps. What's the best way of doing that? And I think, as in most of these instances, what happens, you just work out of the transition, you get through that transition. And it's because we all viewed it, we're one big family. And so there were times when um there were cases that we provided support to because they didn't have the resources, or things were they were spread too thin. And again, we would lend resources to help speed things up, and work together in that respect. And they didn't, the heads of those now district offices, didn't fight against it. They accepted that, and we had all been working together before, and so we continued to work together. But again, it added dynamics that we didn't have previously.
Yeah. How long would you say this working out period took? Was it sort of worked out by the time you became regional administrator, for example?
Oh, definitely.
Okay.
Yes, definitely.
Okay.
Yeah, I don't, I would put, I don't know, probably took 9 months, a little less than a year, somewhere like that.
Okay. Anything else we should talk about before we give you your promotion and talk about running the whole region?
um, Nothing I could think of. You've been pretty comprehensive. You even reminded me of things that I'd forgotten. And I didn't do a lot of homework, but I did a little bit to try to, refresh. But you're down in the weeds. You
Oh
remember
well,
everything.
we don't have to get too far down there, but Well, let's move on then. You became regional administrator in '96. Um,
Mhm.
Obviously, you'd probably had some time to think about this might be the it might work out this way. Were there things you wanted to do? Were there things you wanted to change?
You know, I think what I wanted was not to mess up. I think I had great predecessors, all of whom were my mentors, and I had learned just an awful lot from. And I inherited an office that, sort of, each of them contributed to and built up, and, Dick being the most recent was in fantastic shape. We had great cases. We were well run, um, uh, well regarded and respected within the commission and outside the commission. And I didn't take that for granted. And my concern was how to continue that momentum, keep our reputation and continue to do the good work, and really not mess up, because there are lots of ways that you can have some foot faults, and especially when the buck stops, with and that's, I think, the attitude that, that pretty much, we all had. We're not looking to point fingers or whatever. You have a responsibility. Um, and if there's a problem on your watch, that's your responsibility.
How about learning to manage? I mean, you'd been managing the enforcement, but your management role got bigger. Was there a learning curve in dealing with all the different groups that you had to be responsible for?
Not really within the office, because you know, the first, enforcement had a great relationship with the examination program. And our examination program was second to none. Our examination programs were off the charts. And so, um, they, frequently we consulted with one another. They were our subject experts on some of our investigations, even those that were not referred over by the examination group. But there were plenty of referrals, so we worked some of those cases together. So, sort of as enforcement head, I had great relationships with the heads of those groups, and certainly understood the programs, and understood, some of the more technical, um, rules and regulations applying to the regulated entities. And I even, as head of enforcement, went on an exam, with the focus of really understanding the examination process, and the like. So, by the time I was regional director, I sort of, certainly had understood the office and its parts, and how we function together. And I might add that when I got promoted to associate director and head of enforcement, um, OPM wouldn't sign off on my promotion. They said I was not experienced enough. And so they made me take, it's embarrassing, they made me take management courses for before they would sign off. And so I took a huge number of management courses from the AMA. Uh, and I have to say, I was, really cursing under my breath, and offended, and all stomping my feet. But I learned quite a bit. I didn't take these touchy feely courses, but really, sort of enhanced and crystallized, I thought, my management skills. So I say that to say that I think when I stepped into that position, I really was had experience, and I consider myself to be really a good manager of the program and of people.
Okay. And speaking of people, one of the things that the SEC in general is facing at this point is a lot of turnover.
Ah,
And I know in New York City, you've got it even worse.
yes, yes. I mean, this this was, and I will say that at the end of the day, this is the principal reason that I left the commission that I loved. You know, young attorneys would come and make a 3-year commitment, to the staff, to the commission. And what we found is that, if we got a year, we were lucky. And the burden of that, of constantly restaffing and shuffling cases, and the delay that it caused on cases, and and goodness, the insensitivity and sort of just total disregard by Congress for assistance, when we were contributing so much money to the treasury, and the budget cuts and the hiring freezes, and then the criticism about why we're not doing a better job. Then and I have to say, I thought we were doing a great job under any circumstances, including under the difficult circumstances. So all of that to say that it was a very real problem, and made it almost impossible to do the job.
Yeah. At some point there in the past, there'd been a provision for higher salaries for
Right.
financial. I take it that that was not politically popular at this point, or something.
No, that's exactly right. Now, shortly after I left, that went through,
Okay.
and there was lots of staff raises, and I have to say that the difficulty was also the gap between government pay and private pay. When I first started in 81. I have to say that, yeah, it wasn't comparable, but, it wasn't that big of a gap. My goodness, when I left, with my salary, and I was at the top of the SES scale, my salary plus any bonuses that I might receive was less than a first year associate at a law firm. Like, really?
Yeah.
That makes sense. So, I'm sorry, this is a topic that is really a little bit upsetting for me, because people were just giving themselves, working hard, and then would come to get permission to take on a second job so that they could live up to their commitment, because they got married, they have a child, a new mortgage. Really, really upsetting. But
Right.
so,
Well, it's important as far as trying to manage the regional office, certainly.
right,
Um, well, something
real
that's interesting.
instability. Just my last say, it created real instability
Yeah.
within.
Yeah, and really just because the teams are constantly changing, there's a lot of change.
Right,
Yeah.
right.
Um, Something that I found very interesting is I read that when you became a regional administrator is when you learned that Dick Walker had agreed to create sort of this uh, corporation as, as part of a sting. You basically, your first day they show up and the FBI gives you a little talking to, I guess. Tell me about that. That's
Um, well, I think I, I I don't remember it quite that way. I mean, I remember being brought in to it a little bit earlier than
okay.
that, because this was obviously a really something very, very unique and different for the commission. I mean, the commission does not engage in undercover, participation in undercover operations, and in any respect. And I mean, I remember we used to talk about whether we could go to a public meeting and whether we had to identify ourselves first before attending, ridiculous things that are, no longer issues. But yeah, so I had some early involvement in that. It was something that we had to really make sure that the commission was satisfied with respect to, investor protection. What were the risks? What were the protections against those risks? And what was the upside, to the extent that the risks remained that we couldn't manage? What was the upside that made those risks worth taking? And while Dick certainly was the spearheaded all of that, there was involvement, consultation, and discussions with me around those. But I certainly wasn't involved in the the day to day, and what you're referring to is very true, to actually sit down with the FBI. And also, I had lots of familiarity with the Securities and Commodities Fraud Task Force, but not the organized crime unit. And as I'm sure you're probably aware, one of the reasons why this, what was viewed at the time as a, novel, extreme approach was warranted is because, we had real credible evidence that organized crime was really doing quite well on Wall Street. And, we could never keep pace. They were always, ahead of us. By the time we got there, they were shut down, opened up another enterprise, and defrauding, different investors, leaving lots of destruction in their wake. So sitting down and talking to them and understanding, the risks personally as well, because, they made it quite clear that, that organized crime sort of is not your typical white collar, criminals,
Right.
and that they strike back, in different ways, and how to protect myself personally. It was really it was awakening, slap in the face to wake you up.
Yeah.
Yeah.
And they're riding this sort of new penny stock wave. And it had been a long time since penny stocks had been a big deal in New York. It was a Denver, Salt Lake City thing.
Right.
What was bringing that back in the 1990s?
I think the money is just, as I remember, and this is a vague recollection, that there was sort of they had some challenges in their business of choice, if you will. I don't know, the truck hauling or garbage hauling. There were some a lot of crackdown on much of the corruption in other areas of their business. And so they decided to take some of their methods and apply them to Wall Street and in the microcap space. And so it wasn't just your, the usual manipulations, pump and dumps and, stuff like that, but they were also like extorting and threatening and with, physical violence, some of the participants and players, to hold stock and to invest in some of these worthless companies and the like. So it really was a somewhat, and it wasn't a new front for them, but sort of a opportunity to expand in a front that they had been dabbling in, because we had done before um, the we got to the point that these operations became necessary. We had done parallel cases with the criminal authorities, both the Southern District as well as the Eastern District. But we did see that the infiltration was starting to really be pervasive, and why that was the case, I can only sort of speculate.
Okay. In the end, that campaign went pretty well, though.
Sure did. And remember, there were two operations, and one, Thorcon, was the one that I was, I'd been brought in earlier, but I think Uptick was the one that I was not really familiar with, and had realized that was ongoing. It was a slightly different operation, but they were all very successful. And when they're at the end of the day, when there were indictments, there were a large number. I don't remember the precise number, but a large number of mob members from all five of the crime families that were indicted.
Let's talk about another sort of national thing, which was the focus on soft dollars in the mid 90s.
Yes. So I was thinking about this, and I sort of, I'm not sure whether this was sort of a focus that came out of New York, that was generated from New York, or whether it came from a variety of different sources. Because the one thing I will say is that, I mean, really, New York was, from in terms of the exam program, really on the cutting edge, and so there were times that they would see trends in New York, or spot them, and sort of bring it to OC, and it would get sort of national attention within the commission. So I'm not sure on this one exactly whether it was generated out of New York. My sense, I have a vague recollection that, first of all, I mean, there was just a huge uptick that we certainly observed in the use of soft dollars across the board, not just broker dealers, but also in the advisor space. And then there were a couple of, investigations and enforcement cases that in this area that got the attention of market regulation and investment management. And that attention then flowed over to OC and became part of the national exam program. And there were sweeps that were implemented in order to assess the magnitude of the issue.
Okay. Well, we've been talking about some high-profile things that you've been involved in. And in the financial world, nothing's more high-profile than the New York Stock Exchange. And you had the floor broker case that came up in the late 1990s.
Yes.
Now, I would imagine that this must have been a very delicate situation. Can you tell me about, just sort of take us through that one?
Yes. Look, I think from a dynamics perspective, it was very, very difficult in many respects. I mean, if you think about it, we kind of looked at the SROs as sort of our partners in enforcement. We worked on parallel cases. We referred cases to them. They refer cases to us. Recognizing that there was an oversight responsibility as well, obviously on both the exam side as well as the enforcement side. We really did have that perspective that they were quasi regulators, if you will. And so, there's a little bit of this, but for the grace of God go I, in terms of people, they come in and turn us inside out. They could perhaps take issue with whether we're, effectively enforcing the federal securities laws. Anyway, so the dynamics were tough ones. We approached the case in the same way that we investigated all others in terms of, process. We extensive document requests, extensive testimony, a Wells process, settlement discussions, and obviously there was a very high level of interest and engagement from market regulation, now trading and markets, the Office of General Counsel, the Division of Enforcement, and ultimately the Commission. I think that a couple of things, and first let me also say that the stock exchange was extremely cooperative during the course of the investigation. I think they were ultimately very disappointed in the outcome, that we would recommend an enforcement action, and that we would, sort of recommend the undertakings that we did. I think that, when you look at the, the order, I think, we sort of felt that, given the period of time, sort of the egregiousness of the floor broker misconduct activity. This was actually a case I remember that, it was the Southern District, Reed Feigl, that, sort of in looking, consulting, if you will, regarding some of the more technical rules and things, that we learned that there was, a lot of this misconduct going on, with the floor broker. So the egregiousness of the misconduct, and in our view, the lack of appropriate surveillance, and the customer harm, as well as the potential for even more customer harm. We, at the end of the day, we brought that case.
Right. And another less, maybe something with fewer sensitivities is the Joseph Jett case.
So that one is easy because that was really Marty Kupperberg and Dick Walker who did that one. From time to time, I would, share my outrage around some of the things that were happening there. But this supports my conclusion that it was Dick that actually combined the enforcement groups. So this was a case coming out of broker-dealer enforcement, and Marty Kupperberg, who is the head of that group. Oh my God, what a dynamo! And he was something else. And so I was consulted on that from time to time, but that was really him and Dick that did that matter.
Okay, but this is another interesting one, because in the end they didn't find fraud, or the judge didn't find fraud. It was really a matter of how this guy was compensated, this muni bond dealer.
Yeah, I think that that case was a pretty unsatisfying for a lot of things. I mean, first of all, there was, sort of a internal investigation that was done, by I think Jet was with Kidda Peabody, wasn't he? And I think Gary Lynch was counsel for whether it was counsel to the company or the audit committee. I don't know exactly who did who the client was, but they did. Davis Polk did the internal investigation, and I think that the view that this was kind of a books and records case. And the only sort of bad result was that he was overcompensated for the for um, profits that were non-existent in that space. I mean, I think just is I don't know how you look at the facts of that case, frankly, and could reach that conclusion. So I do think that we were very, as a general matter, unhappy with the outcome of that, for sure.
Were there any other cases that sort of defined your time as regional administrator that we should talk about?
Um, no, I think you've covered an awful lot of them.
Okay.
Yeah, nothing comes to mind really.
We've talked about sort of initiatives from the chairman or from DC, and when Arthur Levitt came in, before there, it's interesting because you talked about Eisen really putting this emphasis on knowing that you had the case right and this was an important case to bring. Levitt's kind of, let's just move the cases through. He sort of issued this position that he really wanted to move the cases quickly. Tell me about how you mobilized in response to that.
Well, I think Arthur as chairman it was very interesting during that period because I think that's kind of not sort of a that statement lacks a little bit of context for Arthur's perspective. And I think, he came to the commission with an incredible amount of experience and, service in the industry. And, to coin a phrase, I mean, he knew where the skeletons were buried. But Arthur was not a lawyer, and so I think he sort of didn't understand why, if this was unethical conduct or there was a lot of harm out of this, but the regulation wasn't clear or wasn't the public wasn't on notice that it was a violation, or perhaps it's not a violation based on the current law. You had to take some time with him for him to grasp that, because his focus was, this is horrific conduct and it needs to be stamped out. And it's that same sort of foundation about let's move these cases. Why is it taking so long? Why are we not getting to this until 3 years after the misconduct occurred? How is that you know effective enforcement? And so I think it wasn't, be expeditious in lieu of, worrying about the quality of those cases and getting
Right.
it right. It was, you do what you're doing, and just do it faster. No, very similar to Harvey Pitt, who I have tremendous respect for, Chair Pitt, with his real time enforcement, right? And getting it done, because these investigations, both when I was on the staff and now when I'm defending them, they take too long. There's no doubt about that.
Okay, yeah, that's interesting though. The context being that Arthur Levitt was not a lawyer and didn't see the building the cases from that perspective.
Right.
But I did come across a quote in a response that you made, is we're adopting a SWAT team approach in order to sort of move more quickly. And as you said, do what we do, just do it more quickly. Tell me about that approach.
Well, I mean, I think that we did focus a lot on, um, working with our partners, and making sure that the right people were taking lead and investigating. And so there might be things that it was better for one of the SROs to focus on, and other times where the criminal authorities should take lead and we provide support, and other times where we should be the ones. But garnering all those resources instead of sort of having a competitive perspective, you're pulling everyone together. Also, it was really focusing on, again, leveraging on our examination program. We did a lot of that. And I mentioned earlier about how earlier in time, when we would think about doing things, there was a question as to whether it was appropriate for a civil law enforcement agency to do that. One of the things that was a question was, can your examination program be a stalking horse for enforcement? And absolutely it can. There just can't be any misrepresentations around it. The examiners can't be in there for cause, and saying, oh, this is just routine, and stuff like that. So one of the things that was being sorted out and being worked out. And in fact, I think in the floor brokers case, I think there were some challenges to the fact that some of the examiners went in and collected information that was ultimately used for the purpose of enforcement. But this was part of our SWAT team approach, is to really think about our resources, what was available to us, what was the most expeditious way of tackling a problem. And sometimes it was sending our examiners in order to, because you didn't have to wait, for production pursuant to a subpoena. They would go in and they'd say, hi, we're here, you're a regulated entity. You have certain obligations to promptly produce these documents for our inspection. And it's something that the staff uses routinely now. But then it was, I wouldn't say cutting edge, but it was just beginning to be utilized on a regular routine basis. So that was kind of our approach, and as well as with the staff attorneys, sort of, and it's kind of a the methodology that enforcement uses with the special units now. We sort of started to, even though it was broken down in terms of having the specialty enforcement areas, we did start to focus again a little bit more on, a couple of people have done these type of cases, more than once. They exactly know how to approach it, what to look out for in developing that case. And so let's give them this one so that they can run with it and aren't learning, if you will, a new area. So there was also a little bit of, sort of leveraging on the subject matter expertise that was, being developed within enforcement.
Yeah, which is something we're going to see later with the special units, which is
Right.
interesting.
That's exactly right. And truth be told, it's funny because when there was, beginning to have conversations, the division was thinking about moving to the special units. When, people, because everyone always reaches out and consults and, to get other perspectives and thoughts. I actually said, I wouldn't ultimately do it because, one thing that happens is that, and we saw this with our approach in New York, that when you went too far to that area of specialization, that, people lost they looked at it only from that perspective. They sometimes missed issues, didn't see, other areas that sometimes were, more problematic than what they were investigating. And so you had a little bit, too much of a narrow focus. And so you had to have, I think, people doing not just the specialty area, but also, the general enforcement area, so that they are able to spot issues and proceed appropriately. But obviously, it's each approach has its pluses and minuses, and I think experience has shown that the specialized units has worked very well.
Yeah. Well, you've sort of talked about, you've alluded to kind of the old regional office model, which is a group of generalists who they've got their area, and that's what they're kings of their domain. And you talked earlier about the sense that there was a little bit of tension with DC. Did you, over the course, I'm sort of reflecting back over how things changed during the 20 years you were there, did you see a fundamental shift in say enforcement and certainly with OC, with the exam program? Did you see those things shift toward becoming more national than regional?
Absolutely. And I think, Lori Richards, when she became division director of OC, you definitely saw that. You saw that, the regions were a very integral part of establishing whatever, the national agenda was for that year. That there were, lots of the exams were joint exams with OC and the various regional offices. And with, look, with that, with a seat at the table and people, sharing their perspectives and feeling that their voices are making a contribution, they're being heard. I think it just naturally evolves into a really strong, positive relationship. And that's what happened on the exam program. And I think, similarly, as I mentioned before, on the enforcement side, it was, very much, the same. And I saw the shift, very shortly after, transferring to the New York office. And I'm not even sure that perhaps if it wasn't, people hadn't, kind of even told me, oh, we thought you were a spy and this and that. I would have been as aware, if you will, of, some of the, the challenging dynamics between the home office and the regions. But clearly, we had a great relationship with the home office, and did lots of collaboration with them, and no issues. I mean, there were time to time where we had disagreements, in terms of, the cases where the division disagreed with our recommendation. But I will tell you that, and I think, very early on, if you had that disagreement, that would have been the end of it, that, you would stand down. For a long time, when I was in senior management positions, we would have a seat at the table and we would argue to the commission our position and why we think the recommendation was appropriate, and the division would talk about what its concerns were and the like. And most of the time that would happen perhaps through briefing of the commissioners and in advance of the commission meeting, but sometimes that didn't resolve it. And if it was something that was important, and we did this on a couple of times, we would say we're not withdrawing our recommendation, and let's take it to the commission in a formal way. Sometimes we won those, and sometimes we lost. And in one particular instance, we lost, and that was the right result, because we later saw that the very concern that the division had expressed, which we had kind of said, yeah, that's like no risk, actually happened.
Oh.
So it was a good thing that we lost that one. But so I think there's just a lot of mutual respect, more of a partnership, and all of one team, again, dynamic, when I left.
How about with the other regions? There used to be every year, everybody come to DC, and spend a week together, talk about things. Did that continue?
I think, look, in retrospect, I think that we could have been a little less aggressive, that I could have been a little less aggressive. We were very aggressive. We did not respect sort of our geography, and we kind of took took the mindset from the Southern District, which talks about the sovereign district, kind of took that approach. And so we were very aggressive in seeking out, new matters and opening them up, regardless of whether they were in another region. And when the region would ask and say, look, what's your interest? Why are you doing this? Shouldn't we be doing this case? We fought, to keep those matters. And in particular, we had that issue with LA. We took a lot of cases that appropriately belonged to that regional office. We had a nexus. We always did, because we have the exchanges, right? So there's trading in New York. But many times, and in particular, Chairman Breeden supported us. One instance in particular, this came up in one of the chief enforcement conferences. So, we had a good relationship, I would say, with most of the offices, but less so with LA.
Interesting. Well, you got to read the newspapers before they did.
That's exactly right. That time difference makes the world of difference. Yes, that's right.
Well, is there anything else we should talk about of your time with the SEC?
No, I think, just to say that it was an incredible ride. I was there, 19 years roughly. And, as when a lot of us get together, as we frequently do, because the bonds that are formed at the commission, long survive our departure from the commission. We all talk about how it'll never, never gets better than that. And that's the truth. It was, a really great ride.
Well, you've done a good job explaining the ride to me, and I've appreciated it. I've enjoyed the ride.
Oh, good.
Yeah. Thanks so much.
Thank you.